Hello and welcome to the lecture. Thanks to the Georgia Game Developer Association for having me and for everyone for tuning in. We'll give everyone a moment or two to just come on in. So to introduce myself, I'm Justin Jacobson. I've been an esports and video game and entertainment attorney for the last decade. And in this role, I handle all the legal and business matters for professional athletes, musicians, fashion designers, video game companies, and all creative individuals and businesses. Nearly 7 years ago, I expanded into the esports world, working with professional gamers, streamers, coaches, casters, teams, and all individuals and companies in the esports and professional game business. I also teach esports and video game business courses at several universities, including at University of North Carolina, Wilmington, Post University in Connecticut, St. Francis College in Brooklyn, New York, as well as teach media law at Hunter College. Finally, I authored The Essential Guide to the Business and Law of Esports and Professional Video Gaming, which is the first textbook on the legal and business side of esports in the professional video game world. Before I start, if anyone has any questions on the lecture or myself, please submit any questions directly to me via email, which is justin@jmjesq.com. Justin, Justin, at jmjesq.com. Or you can reach me via LinkedIn, Justin M. Jacobson, so that's Jacobson, or Twitter, which is Justin JESQ. My DMs are always open, so I'm always happy to connect and see if there's any ways to speak further. So today we're going to explore several matters related to the protection and licensing of a video or computer game, as well as any other IP that's related and owned by a game developer or publisher. Just as a disclaimer, nothing here is intended as legal advice, as all the information for educational purposes only. Everyone's situation is different, so I'm trying to provide some general knowledge that might be applicable in many situations. But again, since every situation, every company, every game is different, you should speak to someone who's qualified and understands this and can speak and provide specific information on your behalf and on your situation. So we're going to start by exploring one common intellectual property protection, which is copyright law. So a copyright is something that protects a specific creative work, such as a song, a book, a movie, a television show, or a video game. While a trademark is used to protect a brand name or product name or company name or a marketing slogan or catchphrase or hashtag or anything used to identify the source of goods. Today, we're solely looking at copyrights in video games, including what parts of a game can be protected under copyright law. So, this means we're going to discuss how a game developer can then license their protected IP to another party, and then some considerations related to entering into a third-party licensing deal, including arrangements with a game publisher if you're a game developer, or a merchandise or apparel designer. This information is potentially applicable for all game creators, whether they're working at a large AAA publisher or a small upcoming indie developer or any software development company in between, as there are many similarities in what a game's creator at any level should be aware of. So to start, we're going to first discuss copyrights in video games. Specifically, there are two copyrights in a video game. There's a copyright in underlying software code as a literary work. There's also a copyright in the audiovisual work, which is the protection in the images, the artwork, the sound, the animations, anything that's audiovisual. As a result, a video or computer game or any software contains and combines multiple protectable art forms, so music and video with written text, a software code that's then combined and used with a computer program that interacts and manages some of the audiovisual elements, which allows a variety of aspects of a game to be protectable. So since a game is essentially a visual work with audio and or sound, that is controlled by a computer or software code. So this means copyright protection is available for any specific in-game character design, any original music and audio elements, such as character voiceovers, any internal or created sound effects. There's also protection for any video or visual elements in the game, such as images, any digitally captured moving images, so animations, any movements, and anything related to how the characters move within the game. There's also potentially protection available for any written text in the game. So the specific gameplay storylines, the imagined environments, and the geographic location names and descriptions. Copyright might also exist in the game's box or disc design, in the finished game itself, and in the actual computer code, including both the software's source code and object code. So this means a developer or publisher in the US can obtain copyright protection in a variety of different components within the game, as well as the actual finished game itself. So just to kind of bring it all together, a game developer could acquire licensable IP rights in the design of any in-game characters, including playable and non-playable characters, which then can be licensed to a third party or used on its own for any derivative works, such as toys, television shows, movies, or any other physical or digital item. Since there's also protection in the digitally captured images and animations, the developer can license or sell these images. There might be copyright protection in the game's written text and the specific gameplay storylines, what's happening, the plot of the game, including the character backstories and everything else related to the storyline, which can be licensed as separate stories or for works based on this information, as we see with certain video games that have created these derivative works, whether television shows or movies or books or anything else. There's also copyright in the imagined environments displayed in the game. So the enchanted forest or any specific unique world that's created, as well as the geographic locations created in the game. So any specific names in the game, any city names that are kind of used, especially creative ones. Finally, the game developer can copyright the actual game cover art, the box or the cartridge design, and any images or sounds or animations in the start screens or the loading screens, anything that you see that's displayed in the game that might not actually be part of the game's mechanics. And as we mentioned, there's a separate copyright in the actual computer code, including the source code as well as the object code, which can be licensed separately from the other protected component. So you have the ability to license characters and storylines and images environments, as well as the game code itself, which gives the developer a lot of flexibility in how they can proceed forward with this copyrighted work. Also, since copyright protection applies for any original music, such as a game's anthem or introduction or any sound clips, as well as any audio incorporated into the game, such as any original compositions, the character voices, and any voiceovers. It's important that if a third party creates any of these sounds or images or animations, that a proper document or rights assignment is signed with the creator or the voiceover artist to ensure that the game developer or publisher has the rights to their musical or video or audio creation, and that the publisher can use this information, these creative works, as they desire. Now that we kind of understand a little bit about what can be copyrighted, we're going to look at, some requirements. So why it's not required to register a copyright with the Copyright Office. There's a variety of unique benefits that a copyright registration in the U.S. provides. While it's established that a copyright is automatically created when a work is fixed in a tangible medium of expression, so once you code and save the game, it is fixed in a tangible medium of expression. However, a formal registration with the Copyright Office within 3 months of the public release of the work, such as the game, provides additional benefits to the game developer. First, the IP is now a matter of public record, so it's available for search through the Copyright Office and the Library of Congress. This fact is very useful because it allows other parties to search and confirm the ownership of a copyrighted work, especially if the third party wants to purchase, use, or license the material. The existence of a registration also allows the owner to easily catalog and license their various rights in the works by having specific registrations for different protected components. So there could be a copyright registration for the finished game, for different character design, for different environment design. So it gives the ability, having these different registrations, for the game developer or publisher to just license one of those to one party and be able to easily state copyright registration 123 is for the character design, and that's what you're receiving. And it doesn't involve anything else that's not within that specific registration. Also, another requirement is that in order to bring a copyright infringement lawsuit, the work must be registered with the Copyright Office. So if a game developer creator believes that their work is being copied or infringed, including any sounds, designs, video, or anything that's being infringed on, they need to register the copyright work before they can even file a lawsuit. Also, if a work is filed prior to the infringement or within 3 months of the original publication of the work, the game creator may be entitled to actual damages suffered by the infringement, which is loss of sales and potential other damages, as well as specific statutory damages, which could be a lot. So these are damages that are prescribed by law that might exceed your actual losses, as well as potentially recovering the suing party's attorney's fees. So that's the funds that are paid to an attorney or a law firm to actually pursue and file the lawsuit and everything related to that, which could be thousands upon thousands of dollars, depending on how long the lawsuit goes for. And if you successfully register your work within 3 months of publication, you have the ability to potentially recover the statutory damages, which could be $50,000, $100,000, whatever, correlates to the statute, or your attorney's fees, or both, as well as your actual losses. So registration of works provides a lot of unique benefits. And again, it's not required, but it gives you all these other ability and stuff that you wouldn't necessarily have if you didn't register the work. Finally, a valid registration may defeat a defendant's defense of being an innocent infringer, which might increase the statutory damages for willful infringements. So the idea is that once a person receives notice of their infringement and they continue and they don't stop, this could be seen as willful, which could increase the amount of damages that a party might recover. So it's really important to understand that once, a created work is created and it's put out there, you can potentially register it with the Copyright Office and get all these additional benefits beyond just the work being protected. So once a game developer actually protects and solidifies their rights in the game, they must be aware of how they can license, sell, or let another party use it. So a game developer has the ability to license their IP, which could be a limited license, which is a right to use the IP or the work for a specific time period, which is referred to as the term of the agreement, the term of the license. As a result of these different copyrights that are available in the game, the developer can license their IP for a limited time in specific categories, just the entire game itself, an individual character, or any other protectable component, such as any music or animation. So this might allow the game developer to license their work to be created or played on one or more different platforms. So just being licensed for computer or PC games, or just for gaming on a mobile device such as a smartphone or tablet, or gaming on a console like PlayStation or Xbox, or all of these platforms or only some of them. The finished game could also be licensed and distributed or sold to the public by the developer themselves directly, or by a third-party licensee, such as a game publisher or any other digital content distributor or platform. Copies of the game can be licensed to a company or sold by the game developer directly to traditional brick-and-mortar stores such as Best Buy or GameStop. They could also be licensed to another party or sold directly to a consumer through digital and online game stores such as Xbox or PlayStation's game store or Valve's Steam distribution service. So as a game owner, you have a variety of ways to actually get your game, whether it's licensing it to another party who will get it out to the public, or doing it yourself. And it could be physical and in stores, the physical discs and cartridges, or just a digital version of the game, which can be obtained through Xbox or PlayStation Store or Valve Steam Store. There are also options for the game to be licensed and sold directly to a user through a third-party app store for it to be used on their smartphone or tablet. So these games can be downloaded for a fee, or the free-to-play ones, from an Apple or a Google's app marketplace. In addition to all these available licenses, a copyright owner could license any of their separate IP rights to any individual or any business that they want to create a variety of products and offer many different services featuring their work. So this could be licensing to a physical merchandise distributor so they can make hats or t-shirts or toys or any other memorabilia or collectibles based on the game's characters. A television studio to create a TV show based on the game or its plot line. A movie producer to create a movie featuring the game's characters or stories. Or even to a book publisher to create a written or digital work that could be behind the scenes of how the game was made, or even written or audiovisual work on how to beat the game or any other derivative works. So as we can see, there are many different types of transactions that an owner of a copyrighted work should be aware of. So a game developer should understand that they could potentially fully sell or assign all of their rights in the game to another party, or they can just license, which is giving written permission to use the IP for a stated period, for a limited purpose, which is not a transfer of the entire right in the copyright, and the game developer, the original owner, still owns it. These situations in a licensing situation could be exclusive, which means that no other party can use the IP for any purpose or just for a specific purpose or forever or for a certain term period. And there could be non-exclusive arrangement so that anyone can use and sell the same IP for a same or similar purpose at the same time. So these are two crucial distinctions, an exclusive versus a non-exclusive license, because an exclusive license can be an exclusive in one territory or for one product or category, or it can be non-exclusive, which means a bunch of different people can work in the same categories and sell the same type of products. There are obviously benefits and drawbacks to both situations, and that's where the negotiation and leverage of each parties come into play. Finally, there could be a third party just receiving written right or consent to use another's work for a specific purpose. So this could be a promotional or charitable or even a commercial one. It's not necessarily a license, which has additional rights and obligations, including potential payments, but it's an authorized use, especially in terms of non-commercial or educational uses. It just says, hey, I'm a copyright owner, you respect my ownership in this, but you can still use this because you're not selling the game, you're not making a profitable movie, you're doing something that's not going to infringe or hinder my ability to fully monetize my work. As a result of all of these different potential transactions and issues, a game developer or any owner of any IP in a game should be aware of and try to best protect themselves when licensing their IP to any third party. So there's a lot of different considerations that are important when licensing a work as a derivative work. So this could be a TV show, a movie, a tabletop game, physical or digital merchandise, or any media or apparel incorporating or based on a protected game or other IP. While every license is unique and important, the first agreement we're going to look at and discuss is the one between a game developer and a game publisher to license a game. So here, a game developer contracts with a publisher for them to finance, distribute, and or sell the game. So it could be just for them to finance it, for them to just distribute it publicly or digitally, or to sell the game everywhere. So there's a lot of different options that this could be. So a publisher could be involved in the large scale and completely fund the game, or they can only be involved in a limited or small role where they're only financing one phase of the game, such as whatever funds might be required to finish a portion of the game, or they might be monetizing the port to a different platform. So there's a lot of different ways that a publisher can work with a game developer. And obviously, whenever a publisher is involved in financing a game development, there's usually a written agreement that's entered into between the parties that's referred to as a game publishing or license agreement, and this controls the relationship. While everything is different, these contracts usually outline the rights and obligations of the parties as it relates to the licensed IP and addresses all decision-making related to a game's development, marketing, and sale. So this could have info on the current and future financing of the title, how much is going to be spent, how much will be spent on sequels, the royalties earned from the game sales, the game's overall development plan and timeline so that everyone's aware of when the game is going to be released, when certain alpha and betas are going to be due, and information related to the game testing and localization, when the different tests are going to happen, when they expect the results. And well, it'll address how and when the game will be distributed, marketed, manufacturers, and in which countries and which platforms. So obviously this document addresses a lot of the chief concerns for both parties, so it's important to be aware and to understand it and to do it properly. There are many considerations for a party when entering into any content licensing agreement, such as a game publishing deal. So the following information is really not exhaustive, as these agreements are usually 20 to 30 pages or longer. So I just highlighted a few important clauses and thoughts that are included in many types of these deals and that are very important to be aware of. So most of these agreements address the scope of the arrangement. So that's stating which rights are provided and to who gets what. Also talks about which party owns the finished game, as well as any associated IP in the game, as the game developer could just sell or just assign some or all of their rights to the game publisher. So this means someone who creates a game could fully, assign or sell their ownership interest in all of the IP or just the game, or they could license or assign some of their rights or all of their rights. As we know, the difference between fully assigning and selling versus licensing is that if you're licensing it, the original owner still owns the copyright, whereas if you're assigning it and selling it, you're giving up all your copyright rights and ownership rights in the work. So there could be a specific carve-out provision or category, so you could license just for merchandise or television or broadcasting, or for all of these, or for a variety of these. That can be for a certain time period, known as the term, in a specific territory or a specific platform. So there's a lot of different options on how you can create the scope and how the deal can apply. This also contains information on whether the rights are exclusive or non-exclusive. As we mentioned earlier, there's a huge difference in receiving an exclusive rights versus non-exclusive rights, especially if it's in different territories and for different platforms. There's also information on which rights are granted to who, or what are licensed to the game publisher. There might be the right just to distribute copies of it, might be just digital or physical or both. And it also talks about who has the right to create or authorize other derivative works based on the IP in the game. So it addresses who can enter into a deal with a TV studio or a merchandise distributor or an NFT company or a metaverse lab in order to license and use the protected work. So, for example, a publisher or any third party can just receive a license for one specific gaming platform, for just console or just mobile. Or this could be just for one geographic territory or country. And in these kind of agreements, it's really important to mention the specific territory or territories. So you should specifically mention which areas, whether it's North America, just the US, or the world, or the universe, the game publisher or any party has rights and what the license applies to, which gives the ability to license your work in different countries. It also gives the ability for a developer to license their game for distribution in different languages. And the different licenses and the different languages should be stated in these agreements. So whatever the licensable language is should be incorporated, as if someone receives the right to translate a game from American, in English to Japanese to be able to sell overseas. It's all important that this stuff is agreed to in the agreement. Related to this, the agreement should state who is responsible for developing all versions of the game for each platform, as the contractor might want to work with another party if a game publisher cannot do all platforms. So it's important to understand the ability to port or porting the game from one medium to the other. These agreements also usually address which party possesses any merchandising rights, as well as any ancillary rights in the derivative works. So the agreement could just be for a single game, or it could include rights to any sequels or prequels or spin-offs based on the original game and its related IP. The agreement will also talk about whether the rights in the game include any downloadable content that's later created and released, or if it's just the initial release. Also, this document, the licensing agreement, might address if the license applies to all games made by the developer within a certain time period or just one specific title. So just the newest Call of Duty, or rights to Call of Duty, every single one that was ever made, or just rights to any game that are made by the developer during a specific time frame. So it could be a 1 or 2 year or however long the contract says. Anything that's made by the developer during that time period is owned by the publisher. So there's a lot of different ways that extensions can be developed. Another really important consideration and something to be aware of is that these kind of agreements should clearly identify any other third-party licensed material that's in the game, so that the game publisher is aware of this and that there's the rights to this material. So this can be any licensed third-party music that's in the game, any images or logos used in the game. And it's important for a developer to be aware that they must acquire the rights to sublicense this work or already possess it in their original agreement with the party they're receiving the rights to, or else the developer might need to get a new license for this transaction. As we mentioned, the term is the length of the license. So this could be a set time period such as days, weeks, months, or years, or it could be licensed in perpetuity or for the life of the copyright, which in the U.S. is the life of the author plus 70 years after their death. The term also talks about what guaranteed time periods of a license exist, referred to as firm commitments, and also might include information on any options, which are the right to extend or renew the agreement. And these approvals to extend it could be based on mutual approval of both parties, one party or the other's choice, if the game receives certain sales milestones, or any other criteria that the parties agree to. So it's really important to understand how long a license lasts, because if it's going on for years or years, that's a big deal. In addition to the term, it's really important that the agreement talks about the compensation, including the licensing fees, royalties, and any profit sharing that the parties might have. And many times, a game developer receives an upfront payment known as a licensing fee or an advance that's paid by the game developer and lets them acquire rights to it. So the game publisher pays this money to the game developer, this licensing fee. That's usually recoupable, but in other terms, it could be non-recoupable. And it might be paid as one lump sum upon signing, or it could be broken up into smaller payments related to specific milestones or calendar year. It could be dispersed quarterly, or once the alpha or beta, or once they have a final test. All of these different milestones that the parties will agree on in writing. Most of the times, an advance is recouped from all revenue streams related to the game, but a party can agree on another arrangement so that certain revenue streams might be excluded from recoupment of any advances that the party gets. So this might be the game developer excluding merchandise income, as those are not really related to the game development costs. So it might be a way for the game developer to not have any income that comes from that income stream be credited. So the way it kind of works is if you get an advance that's recoupable, any income that's then earned from the property is then used to repay and recoup that amount before anyone else receives any money. So if you earn a recoupable advance of $50,000 from the publisher, then the game sells before you get any more money, or if you get a percentage of the income, the initial $50,000 advance must be recouped before anyone else gets anything. So essentially, that could be from game sales specifically, or from all revenue streams, or from merchandise or IP rights or anything else that the parties agree to. So obviously, it's very important for this to be discussed in these agreements. Additionally, it's important to understand the difference between gross and net profits. So gross is all the income received by the publisher or for a specific income stream, and net is all the income after the deduction of any expenses. So it's important to understand the difference, because expenses in many of these cases could be substantial. Also, it's important to be aware that if a developer or party is earning from the net revenue or the net profit, that they should ensure any expenses or deductions are maybe improved in writing or reasonable and are clearly identified, or maybe have some monetary limitations that says any expense over a certain amount require prior approval. And these are different ways to potentially add checks and balances when working with two different parties, especially if one party is earning from the net revenue. In addition, these licensing agreements list each party's obligations and commitments to each other so that everyone's aware of it and there's no misunderstandings. So, for example, a publisher might commit to actually publish and release the game, as well as to provide marketing and promotional support for the release. There could be language that requires a certain amount of marketing funds, or even requiring the publisher to release the game by a certain date or within a certain time frame. So 90 days after delivery of the game, 60 days after final approval. This way, there is some time frame and there is some commitment on the side of both parties to get this game to market. These agreements also list any promotional and advertising commitments, such as creating trailers or advertising campaigns, whether it's social media driven or influencer driven. These agreements might also look at how post-launch support is handled. So since post-launch support occurs after the game is released, the developer might need to continue to work on the game, such as bringing any gameplay patches or fixing any bugs or errors. So if a developer is obligated to provide post-launch support, they may try to negotiate and include in an agreement that they receive additional compensation for this support, whether it's paid on an hourly rate or more just any other rate that they agree to. It could be seen as a subsequent advance to continue to support the game. And this language could be done for any support, or they can limit it to just serious issues or both. So it's important to be aware that even after a game is launched, there might be additional obligations that a party might owe to the other. And it might be important and beneficial to try to get additional compensation for that time period. In addition, these licensing agreements also should discuss and address creative control over the game, as well as any derivative works. So this includes any approval or consent for any marketing materials. Some party might have final cut or some other reasonable approval right over whatever use of the IP, especially if another party is editing the finished game or character design. There might be approval rights for the product packaging, any digital or print advertising campaigns or posters, any merchandise design, what the whole overall mechanics of the game pricing, including the initial price and any discounts. So it's really important to understand that there's a lot of different approvals that can be in writing, and as a developer, you might want to try to have some approval rights, or at least the ability to mutually agree on certain changes, especially if they're huge or material. And then as a publisher, you might want to have the right to market it how you want. So there's a lot of considerations on both sides, and it's beneficial for everyone to have it in writing so that there's no issue and there's no misunderstanding over who has the right to approve what. These agreements also have milestones, which kind of list when certain modes or game character builds are due. And there might be corresponding payments to each milestone, as we mentioned. These could be recoupable or non-recoupable advances that correspond to the different milestones or events listed in the agreement. Additionally, these agreements have information on the term of it, as we mentioned earlier, as well as termination of the agreement. So it looks at how long the licensing deal is and what happens after it ends. So in some situations, the licensing party might have to immediately cease using their IP rights that they received, or remove any reference to the IP from all materials. So there could also be the inclusion of termination clauses, such as moral clauses, which allow a party to terminate an agreement for any unsavory or unethical behavior. We've seen in the game developer world and game publishing industry where some companies may have different scandals or come to public ridicule, and there might be ways to use a morals clause or reverse morals clause to kind of and then terminate your agreement early as a result of violation of this. Important that these different agreements address termination and what happens if it ends naturally or earlier. Additionally, there might be the inclusion of agreements that the developer might have the ability to terminate the agreement early if the publisher is not fulfilling their obligations. So not publishing the game in a certain time period, or not marketing, or not making payments. So there's different things that would be incorporated in the termination of the agreement, whether it's at the end of the term or if certain things happen, like failure to make payments, or if any scandals or public issues happen. There could also have what's called a reversion right, so that the IP rights revert back to the original owner if the termination happens. So if the agreement expires, there could be this reversion where the rights go back to the developer. There might also be what's called a kill fee. That's incorporated if a publisher wants to just end the agreement early. So this might be a set amount that they're paid in order to just kill and terminate the deal, because maybe they're on the hook for larger marketing or additional payments, and it's easier for them to just spend a little bit money now to get out of the agreement, which lets them not have to fulfill those additional obligations, and then lets the game developer go and find maybe another party or do it on their own. So there's lots of benefits and lots of important things to understand when you're crafting the termination and the expiration of agreement, because it might expire based on when the term ends. So if it's a 3-year deal at the end of 3 years, or earlier based on a lot of different factors. And if it does happen earlier, you might want to have a reversion right, so you can then go and find another party and you get all your rights back. Additionally, these agreements also talk about everyone's termination rights. So what happens post-termination? So this talks about if the developer regains all of their rights, or if the party can continue to use the rights they already have, but they don't get any new ones. There's also sometimes considered a holdback or a non-compete provision after the expiration or termination of agreement, which prevents the developer from working with or on a similar game or releasing something, the same kind of new game within a certain time period. So this is really important to understand, that there could be this holdback or non-compete time frame after it exists, where maybe you have a 3-year deal, but then you have a 6-month holdback period where for 6 months after the deal ends, you can't release a similar game or a competition game or the same game with another publisher or on your own, because it might compete with theirs. So it's important to understand this and agree upon this, because obviously the longer non-compete or holdback, the longer you're not able to monetize and sell a game. Another provision that might be included in some of these is called a right of first refusal or right of first negotiation. These are similar because they give you the same idea, where the publisher might have the first opportunity to negotiate exclusively with the developer for a certain right. So this gives them the idea of being able to have a right of first negotiation and refusal for a movie or TV show or a sequel or prequel or spin-off. And this is included in the agreement. Similar, there might be what's called a right of last refusal or a matching right. So this could apply to any television or motion picture or any derivative works, where the publisher will have the opportunity to match any offer for any of these rights the developer gets, so that if the game publisher matches the TV deal, they have those rights. Additionally, many of these agreements require each party to police and provide notice to the other of any infringement or any authorized use, and to make sure that no one's breaching the rights that either party has and stopping all the unauthorized uses of the game. These agreements also have warranties and indemnification clauses, and they're really important to understand. So warranties are legal representations that confirm facts that each party says, I warrant that this is correct, and that, for instance, that the licensed work doesn't infringe or violate any third-party IP rights, that I have all the rights to what I'm giving you, that I've done everything on the back end properly. And this is really important, especially if a game developer hasn't, or if they're not running as smooth as they should be. So related to this is called an indemnification clause. So what this means is that if one party is sued or subject to a potential liability as a result of another party's breach of one of their warranties or one of their duties, The non-breaching party will be indemnified, and essentially the breaching party will have to give whatever the losses are caused by the violation of any of the warranties or conditions of the contract. So if a party is sued for $10,000, they lose and they have to pay it, the breaching party will then have to reimburse and pay that amount on behalf of that party. So it's really important to understand this concept. Finally, it's important to understand the governing law for the agreement, such as what country applies and governs the deal. And this is really important as there's a lot of international and foreign publishers, as well as working with different companies in different states. As the gaming industry is so global, it's important to understand what law applies to the agreement, what jurisdiction, whether you are in New York or California or the Netherlands or the UK or anywhere else that the game developer is located or where you're located, and what law applies, because different countries have different laws and different regulations. So that's a little bit about the game publisher and the game developer agreement. This agreement obviously is very crucial and very prevalent, as there's many times that a game developer licenses their work to a game publisher who finances or helps get the game and publicly distribute it. So there's also licenses that exist between the game developer and a third-party digital distributor of the game, such as a Steam kind of platform or an app in an app store. While these agreements are usually pretty standard, it's really important to be aware of the terms of services, as these are the documents that control and determine each party's rights and everything related to the use of their distribution platform. While again, these agreements are usually standard and there's not really much negotiation available, those quick wrap, agree to kind of documents, the game developer should always be aware of what Apple or any other app store is storing and collecting, and what user data, especially their personal data, is collected. Since a digital distributor is giving developer access to a game that could be available and downloaded by anyone, anywhere, the owner should be aware that they're now subject to laws in different countries and different jurisdictions, which might each have their own relevant privacy and consumer protection laws, as different states and different countries have different laws, as well as different standards of decency and obscenity. So content might be legal in one country or jurisdiction, might be illegal in others. So it's just important to be aware that when you are using a third-party digital distributor, especially one that's available in many different jurisdictions, that there's a lot of different legal matters that go into it, and all of these matters are governed by the terms of service that's issued by the provider. So to kind of bring this all together, we'll look at one other kind of licensing arrangement that's very common in these areas. So this might be where the game developer enters into a third-party license for a TV studio or movie production company or clothing distributor or any other party that's going to make a derivative work based on the game. It's not necessarily a party that's going to distribute the game to the public, but one that's going to take the storyline or the characters or any other protectable IP and license it and monetize it. So this could be a deal with a movie studio, and in these kind of agreements, it might discuss what platforms are available, who has the right, where the film can be displayed and distributed, such as just in local cinemas, just in DVD formats, or just digitally on demand, or pay-per-view platforms, or streaming platforms, or all of these, or mix and match. So there's a lot of opportunities to have different licensing capabilities and to learn income from all these different avenues. There could also be a deal with a television studio, and these kind of agreements might discuss what platforms are available, whether it's cable or satellite or subscription-based platforms or pay-per-view or for on-demand viewing and any OTT platforms. So again, these agreements, which are usually licenses, but they could be full assignments of the rights, will say what platforms are there. And if you license just for cable, you have the ability to license for pay-per-view or subscription-based platforms or satellite. So it's important to understand that these could all be separate deals that could have different fees. So if you're licensing for video on demand versus a streaming platform like Hulu or Netflix, the owner might be able to receive additional payments for all of these. So as we mentioned earlier, these kind of licensing deals usually talk about the licensing fee paid to the IP owner, which again could be recouped or non-recouped. And they also talk about the residual payment or royalties, or a combination of both that the owner will earn, which could be based on the length of term of the agreement, the exclusivity, which are all important things to be included in all these agreements. So whether a party receives all derivative rights or just to make a movie or a TV show or a book or an NFT, and what territories they apply to. As we've learned, you can license a work, whether it's for distribution in one or more different countries or the world or just in Europe or North America or any other territories that the parties agree to. You can just do just in United States, Mexico, and Canada, and the UK and Australia. So there's a lot of different combinations, and all of this will be agreed in writing. And what's nice is if a developer doesn't license their work in a specific country or territory to one party, they can license it to another. So if you have, an English version of your TV show, you can license a Brazilian or a Spanish or Portuguese version in all these different countries. So again, it's very important just to be aware that these are different things that should be addressed in writing. Finally, in these kind of agreements, there's also information on whether the party can sublicense to the others. So does the movie distributor have the right to add subtitles and dub it and sell it and distribute it in different countries, or can you do that as the original owner? Also, since, as we mentioned, there's many different protectable works, whether it's a specific character or storyline, there's important to have creative control over the derivative work. So this information will be created in writing. So this could be approval rights over any digital or physical advertisements, any product or movie posters, any advertisements used for selling merch, as well as the final product design or TV show. So you might have final approval over what a TV show's title is, or what the poster is, or what the trailer looks like, or even what a product is designed, or what a t-shirt might look like, what the hoodie looks like. And these are all important things that need to be agreed to in writing with any party, and especially these ones when you're taking your creative work and you're distributing it to the public. Also, it's important, as mentioned, that these agreements talk about whether it's a full transfer or just a signing or selling a specific right, and the stated time period. And what's unique in these entertainment worlds is that it could be calendar years, or it could be based on a release cycle. So this could be 1 year after the movie is released, or 3 months after the last television show is aired, as these might not necessarily be one calendar year, as it may take months or years to develop a TV show or a movie. So the term might not be based on 3 years. It might be based on 4 years after the movie is released. And if the movie takes a year or two, you're talking about 6 years or more that those rights are tied up. In addition to all of this, it's important to understand what happens after an agreement ends, as the studio or clothing distributor might have to immediately cease using or selling any items with the IP rights, remove any references, so they might have to pull it from Netflix or Hulu when their right ends, or they might have to take it offline if it's being sold online, or take it out of stores. However, in these types of agreements, there might be additional language that might be used here. So there could be things that prevent stockpiling, which is when a party purchases an excessive amount near the end of a term, usually a lot more than they've ordered before, to kind of stockpile the merchandise, as well as prevent a party from dumping or doing fire sales of the product, where they're selling their product for substantially less as a reduced price just to kind of get rid of it. Again, in these types of agreements, each party acknowledges each party's exclusive rights in their works and agrees not to challenge it. There might also require each party to take whatever steps are necessary to protect the IP, including policing any counterfeit or gray market goods, stopping any illegal recordings or video streams, and stopping any pirated copies or any other illegal use. Again, this is all just really a quick glimpse into these large and elaborate agreements, as the best advice is to work with a competent and experienced attorney who understands this and works with these type of agreements and deals on a frequent and extensive basis. So I know we've gone through a lot, but I hope everyone really enjoyed it. So thank everybody for listening. I hope I provided some useful information for you. If you have any questions or concerns, please remember to submit any questions you have via email, justin@jmjesq, or reach out to me via LinkedIn, Justin Jacobson, Jacobson, or on Twitter, JustinJESQ.